Today's blog post reviews House Bill 134 of the Utah 2024 legislative session entitled Marriage Modifications. It addresses the validation and recognition of a marriage regardless of the race, ethnicity, or national origin of the parties to the marriage, and would repeal a current provision in the Utah Code on interracial marriage, i.e. Utah Code Section 30-1-2.2. House Bill 134 would, if passed into law, enact a new code section, proposed Section 30-1-2.4, which is proposed as follows. Quote, 1. As used in this section, governmental entity means the state, a county, a municipality, a special district, a special service district, a school district, a state institution of higher education, or any other political subdivision or administrative unit of the state. 2A. A marriage between two individuals may not be deemed invalid or prohibited on the basis of the race, ethnicity, or national origin of those individuals. B. A marriage between two individuals that was not valid or legal before July 1, 1965 on the basis of the race, ethnicity, or national origin of those individuals is considered valid and legal in this state. 3A. A county clerk may not refuse to issue a marriage license on the basis of the race, ethnicity, or national origin of the individuals applying for the marriage license. B. If an employee, a public official, or a designee of a governmental entity is authorized to solemnize a marriage under Section 30-1-6, the employee, public official, or designee may not refuse to solemnize a marriage on the basis of the race, ethnicity, or national origin of the parties to the marriage. 4. A governmental entity or an employee or public official of a governmental entity may not deny a right or claim arising from a valid and legal marriage between two individuals on the basis of the race, ethnicity, or national origin of those individuals. So, is House Bill 134 a good idea? In my view, no. Utah does not ban interracial or interethnic marriages, nor does it ban marriages on the basis of one's national origin or origins. We have no need of a law that recognizes as valid marriages that are already legally valid. I am not aware of anyone being denied a marriage license or marriage on the basis of his or her race, ethnicity, or national origin in Utah in my lifetime either. I was born in 1968. Utah's anti-miscegenation statute was repealed in 1963. House Bill 134 appears to me to be unnecessary. If you were wondering whether Utah has a law on the books currently that bans or imposes restrictions on interracial marriages, it's nothing that scandalous. We don't have that. Here is the law that HB 134 would be proposed to repeal. It's Utah Code Section 30-1-2.2, entitled Validation of Interracial Marriages. Quote, all interracial marriages, otherwise valid and legal, contracted prior to July 1, 1965, to which one of the parties to the marriage was subject to disability to marry on account of subsection 30-1-2 sub 5 or 6, as those subsections existed prior to May 14, 1963, are hereby valid and made lawful in all respects as though such marriages had been duly and legally contracted in the first instance. Close quote. Indeed, the House Bill 134 sponsor, Republican Representative Anthony E. Lubay, who told St. George News, quote, it was very clear that you couldn't discriminate against somebody getting married based off their race, ethnicity, or national origin. But what this does is update the code so it reflects what our current practices are, and then allows people the peace of mind knowing that if anything ever happens or changes on the federal side, they still have their protection on the state level, close quote. Now, I don't know what he meant by that or was trying to mean by that. Even the bill's sponsor thus acknowledges there is no gaping hole or shameful stain on Utah law that needs to be addressed with any new law. There is no justification to fix what ain't broke. The last thing we need is superfluous laws on the books like this.